You brought a medical malpractice lawsuit against your careless doctor, and you learn that the doctor has only a $1 million insurance policy. And now you tell your attorney that if you decide to settle, you want to squeeze every single last dollar, and you want the full $1 million policy. You think you'll get that? What happens if they turn around right before trial and offer you $950,000? You take what's behind door number one? Or do you say, screw that, I'm going to trial unless I get the full $1 million? You want to know the answer? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You brought a lawsuit against your careless doctor claiming that he caused you significant harm and injury. And now, after 2 hard-fought years, the defense finally decides to start to negotiate. They call up your attorney and say, listen, we'd like to try and negotiate. They haven't offered a dime before this time. They haven't suggested that they were willing to negotiate. In fact, at the very beginning of your case, the defense attorney told your lawyer that they would never settle this case. Now, during the course of the lawsuit, the defense attorney had to notify your lawyer how much available insurance the doctor had. And he had to confirm that in a written letter, indicating how much he had and whether there was excess insurance. In other words, whether there was an additional insurance policy available, and in some instances there are. In this particular case, there was no excess insurance. The maximum insurance policy that this doctor had was $1 million. Now, during the course of negotiations, the defense turns to your attorney, and after weeks of negotiating, they say, listen, the insurance policy is $1 million. We are willing to discount that right now to settle this case now, instead of going to trial. And now, if you want to settle it, the number is $950,000. Now, you've already spoken to your attorney, and you want every last dollar from this doctor's insurance policy. You want to squeeze him out of every single thing you can get. Why? Because you believe the doctor was careless, and you believe that the doctor refused to accept responsibility for his actions, and now made you go through the entire lawsuit process. And now here you are more than 2 years later, and for the very first time, you're having real settlement discussions. The defense now offers $950,000 to settle this case, and they tell you they're not paying a dime more. And you want another $50,000 in order to wrap this case up. Your attorney tells you, if you don't settle this case now for this amount, you go to trial and you run the risk of losing this case. He will tell you that you also run the risk of getting a decision in your favor, but now the jury could give you less money than what you are currently being offered. Alternatively, the jury could ultimately find in your favor and compensate you for substantially more money than you are asking for, or that the doctor is capable of paying right now. The jury could come back and decide that you are entitled to receive $10 million as full and fair compensation for your injuries. The jury's decision has nothing whatsoever to do with whether or not the doctor has insurance or how much insurance he actually has. Plus, the jury is never told about any settlement discussions that go on prior to trial or at any time. The jury is trying to make an informed decision based upon the testimony that goes on at trial, the proof that's presented, as well as expert testimony. So what do you do in this instance where you have told your attorney that you will not accept a dollar less than the full $1 million that the doctor has in available insurance? Well, in this instance, if you're not going to accept a dollar less than $1 million, guess what? You, my friend, are going to trial, which means there is a risk that the defense will pull their offer off the table. And now you get whatever you get from the jury, and then you have to deal with it. Keep in mind that if the jury comes back with a very, very substantial verdict in your favor, I can guarantee that the defense is going to appeal. And they will do everything possible to appeal and do everything possible to try and get the case thrown out after the verdict is rendered. And then they'll do everything possible to try and minimize and reduce the amount of verdict that you were given. On the other hand, you could accept what's behind door number one, which is a guaranteed settlement amount of $950,000. You could swallow your pride. You can accept the fact that you won't be getting the additional $50,000 that you wanted, that you would have liked to squeeze out of the doctor and his insurance company, and you can go home and call it a day. And this way, there's no risk. you have a guaranteed amount of money that you and your attorney will be receiving. That's a guarantee. On the other hand, if you turn down what's behind door number 1 and now opt for what's behind door number 2, which is an unknown, now you run the risk of losing your case. You run the risk of getting less money from a jury. You run the risk of getting more money, and then we call that buying yourself an appeal. And now you have to go through the appellate process, which could take another 1 to 2 years. And again, with the appeals process, there's always an unknown. The appellate court could turn around and say, no, there were mistakes made during the course of trial. We're going to send you back for a new trial, and you try this case all over again, which means you're starting from scratch with a new jury, and now you have to present all your proof all over again, and now hope that a jury does the right thing and gives you the appropriate verdict. Or the appellate court could dismiss your case, claiming that there are errors of law and that this case never should have been brought or proceeded. There are many, many options that the appellate court has, and because this is an unknown, you are now taking a risk, and this is a gamble for you and your case. So to answer the question I raised at the beginning of this video, what do? The reality is, you and you alone, after consulting extensively with your attorney, have to have an educated discussion about whether or not to accept this offer, or whether to take the risk and go to trial. And you might also ask, hey, wait a second, if you go to trial, can you settle the case during trial? The answer is yes. There are instances where you can go ahead and settle the case during trial, but that assumes a couple of things. It assumes that the original settlement offer is still on the table. It may not be. It assumes that the defense is still willing to negotiate, and it is possible that if the defense goes ahead and negotiates, they come in with a lower number than what they had originally offered. In that case, you are stuck. And now again, you have to go through this risk analysis to see whether or not it's worthwhile for you to go through all the way to verdict, or to take what's behind door number 1 and accept the guaranteed settlement offer, as opposed to taking what's behind door number 2, which is, again, a total unknown. So why do I share this quick information with you? I share it with you to open your eyes and help you understand how these types of cases work in New York. You and I realize you're likely watching this because you wanted to see the gorgeous scenery. No, I realize you're watching this because you likely have questions or concerns about your matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.